Hey y'all, welcome back to the channel. Hope you're having a good Friday. Had a good week, and hopefully you have an even better weekend. Quick immigration update. This one revolves around some of the actions President Joe Biden can take when he assumes the office of the presidency on January 20th. 4 days ago, the Electoral College confirmed the results of the election. So we will be officially assuming the role of our president of the United States. And when he does, him and his team can issue, a series of not only executive actions, but deregulatory actions as well that can improve the efficiency and cost effectiveness of our immigration system, which immigrants and Americans alike both rely on. The Cato Institute recently published a great article listing about 30 deregulatory actions President Joe Biden and his team can take when he assumes the office of the presidency. If you have not read this article, we're going to link that article in the comments section below of this video. I suggest you follow the link, take a look, give it a read. It's a very interesting read, and you probably will learn a lot. My law partner, Ali Balor, as well as the senior associate in our office, Scott Emmerich, both were quoted in this article for the input they made to the list as well. I'm not going to go through all 30 deregulatory actions that can be done. I'm just going to highlight a handful or so that you may find interesting. And if you have any questions, as always, don't hesitate to reach out to us. So let's get down to it. The first thing that that came to my mind is that allowing parole for the immigrant visa backlog. In essence, this would allow, family-based applicants. So applicants from family-based petitions whose I-130s have been approved. They've already submitted all the documents to the National Visa Center, and all they're waiting for is their visa category to become current in order to then, get their interview at the consulate and have the issuance of the visa in their passport. What this is saying, they could allow these type of applicants who are simply awaiting the visas to become available. They've done everything else, and now they're just waiting for the visa to become available, which is not because of the backlog, to allow these people to receive parole into the United States to be reunited or be united with their family, and allow them to wait here in the U.S. for the visa to become available. They would also be allowed to legally work in the U.S. This would help with family reunification, and I think it would be a great benefit to the efficiency of our immigration system. So that was one. Let's see here. Excuse my scrolling, but I'm going to go to this list here real quick. Expand USCIS interview waivers. Now what this means really is, there are some applications that are filed with USCIS. Let's say a 21-year-old child, U.S. citizen child, petitions for his parent for a green card which is called, an adjustment of status. The parent's here in the U.S., they have a legal entry, the kid's now 21, and as a U.S. citizen, he can petition for his parent for a green card through the adjustment of status process. Now, a lot of times they're pretty straightforward. The evidence is clear that the parent qualifies for the green card for adjustment of status. USCIS, through its biometrics system, can also confirm whether or not that parent has committed any crimes that make him or her inadmissible to the U.S. If they determine no, then really no interview should be required for these types of cases. They could waive the interview once they see that the documents and everything else that has been submitted does clearly indicate that the parent qualifies for the green card for permanent residency, and approve that case without the need for the interview. Not only will this help reduce the backlog and the wait time for the number of cases that are filed with USCIS and speed up the process of adjudication, it would also lessen the cost to USCIS, which is a benefit all around. So that's just one example. There's many other examples where cases can be approved without an interview process because on their face it's real easily to be seen that the case is approvable without the need for an interview. So that's number two, really. Now let's see here. Excuse me. So deem a grant of temporary protected status as an admission. Now this really is, they're saying nationwide, if someone receives TPS, which is temporary protected status, and they're here in the U.S., Nationwide, it should be deemed as a legal admission to the U.S. Here in the Ninth Circuit in California, it is deemed as a legal admission. So those individuals who receive TPS, if they then, let's say, have a U.S. citizen spouse, they can effectively, if they don't have any crimes that make them inadmissible, they can apply for adjustment of status on account of the legal admission, having a qualifying relative, and being otherwise admissible to the U.S. They can apply for adjustment of status. What this is saying is this should be the case nationwide. It should be uniform nationwide. TPS, if you receive it, should be viewed as a legal admission regardless of what jurisdiction you fall in. I do agree with that as well. Moving right along, here's one that stands out to me that can be easily done and I think makes a lot of sense, is let L2 and E-spouses work without a work permit. So E-spouses are spouses of E2 visa holders, which are investment visas. When these E2 applicants, their visa's approved, they come in with their wife, husband, spouse, whatever, and as well as children. What this is saying, rather than when they enter the U.S., making the spouse file for employment authorization by filing I-765, waiting another 5 to 7, 8 months, however long it takes to get that employment authorization issued by USCIS, allow these E-spouses on account of their status here in the U.S. of being a spouse of an E2 visa holder to work legally in the U.S. without the need to then apply for work authorization with USCIS, which can take, again, up to 8 months. And the same for the L2 spouses as well. I think that makes a lot of sense and want to prove, again, the efficiency and cost effectiveness of our immigration system. So without getting too deep or long in this video, those are a few that stand out to me. I really look forward to President Biden, assuming office of the presidency. Not only are there many executive actions as well as deregulatory actions that he and his team can make to improve the efficiency of our immigration system, but also just changing the rhetoric of immigration in and of itself. It shouldn't be seen as something negative. We're all immigrants here in America, whether you're 4th, 5th, 6th, 7th generation. At one point in time, we all did immigrate here into the U.S. This isn't something that should be viewed negatively. It should be seen, immigration should be seen in a positive light. And I look forward to President Biden and his team, switching the narrative and making some good decisions along the way that improves our system and makes it more fair and for everyone, really. Hopefully you found this video helpful, interesting, useful. Again, check out the Cato Institute article linked down below. And if you have any questions, please do not hesitate to reach out. This is Alex with the Belor Carl Immigration Group, coming live from Carmel, California. Be good, be safe. Talk to you soon.